Thank you, and good afternoon. We take up today's subject, the trans insurrection, because of recent developments of interest, including some that took place even this week, which we'll get to in due course. But first, some introductory points by way of context. My work recently has had me giving attention to variations on the theme of the law's scientistic resistance to human nature, in which the meaningful and normative aspect of divine creation is suppressed. The world is then analytically reduced to a mere physical cause and effect mechanism, the significance of which is that the entirety of the created order, including we folk, is together considered and understood in terms of quantity and performance measurability. And this techno-functional description purports to be the vantage exhaustively revealing our public meaning as persons. The moral, spiritual, and telos-rich dimension of persons, if there is one, is a comfort for you to discover and cherish in your private opinions, religion, or other allegedly non-public forms of consideration. This late modern outlook is manifest in the machine logic that again conceives even of the human body as a utilitarian device to be directed toward purposes selected either by the Gnostic ghost that inhabits it, sitting in the cranial driver's seat, or by persons in positions of power and control who wish to exploit it. Thus do we have, for instance, the law-authorized market in gametes and surrogates, law-enabled and tax-funded abortion and assisted suicide, the redefinition of family in terms of androgynous functionality rather than in terms of procreative nuptiality, the fashionable understanding of the nation merely as an economic zone whose inhabitants are taken to be human resource slurry, the recent emergency rule by scientists alerting us that good citizens are those willing to serve as docile pincushions for experimental pharmaceutical jabs. And of course, there's the main subject of my comments this afternoon, the transgender insurrection, which is machinic all the way down. This scientific, materialistic approach to the world and ourselves entails a total critique of the Western historic social legal order, which is theologically and philosophically founded and inflected while rooted in custom and tradition. While the scientific revolt against this tradition has been centuries in development and refinement, through that time it has been held at bay by the continuing preservation in law and its institutions of a recognition of and deference to created nature. That description no longer holds across the board. For the law itself, in certain of its prominent subdivisions, notably constitutional law, has had an active role in the project to eliminate all vestiges of natural order from acknowledgement in public reason and guiding human relationships. Now, the rapid ascent to prominence of transgender ideology is a thing of wonder. Its incoherent thesis attained not just plausibility, but mandatory certainty in a seeming blink of an eye, which suggests that we were already primed for it. One might say that its premise has been among us in inchoate form for quite some time. In any event, it is entrenched in elite community dogma, K through 12 and higher education curriculum, popular entertainment, media speak, corporate policy and advertising, and legislation, regulation, and in judicial rulings across the land, commanding a whole range of counterintuitive and disruptive inversions of policy. And in a special high-handedness, courts have claimed power to commandeer the English language, inverting male and female, he and she, and requiring conformity to that upheaval. Now, as you well know, the idea behind all of this is based on something called gender identity, an innovative and fraught term whose meaning and implications merit consideration at length, but for now I'll just summarize it as the antithesis of embodied identity. The proposal by genderists that certain people are born in the wrong body is unintelligible. To paraphrase Jerry Bradley, saying born in the wrong body is something like declaring that one was born to the wrong parents. Of course, there is no you except you as the child of your mother and father. Likewise, there is no you except the you of your embodied male and female being. The metaphysical truth, Bradley says, is that our bodies are ourselves, whether we like it or not. So a trans claim, rather than being an identity, is the subversion of the very concept. A trans identity, so-called, is an unfalsifiable declaration. It is ghostly, occult, pegged to nothing, a mutable effervescence with no public appearance, relevance, or coherent description. Why then would we attach to such unintelligible status the words that describe the physiological embodiment of male and female? As I penned some years ago, once bodies are shorn from identity and deemed silent on personal classification, there can no longer remain male or female, he or she. The affront in the vocabulary hijacking project is that words of identity marking what is immutable, momentous, public, and visible, that is, the sex of persons, are inverted to mark instead what is mutable, mundane, private, and invisible, that is, the desires of persons. When pronouns are transmuted into a proprietary feature of individuality, she can no longer designate a category, as there are no points of apparent commonality among those who would choose to affiliate with that now emptied word, no longer referring to a physical form. Once a wish supplants the thing wished for, the wish itself, now bereft of its object, dissolves. And when such a wish defines human identity, it is we who dissolve. C.S. Lewis succinctly described the dynamic and the futility of this sort of project when he wrote, "It is like the scent of a flower trying to destroy the flower." Just over 2 months ago, the U.S. Supreme Court heard arguments in the case of United States versus Scurmetti. That case concerns a statute that the Tennessee legislature enacted in order to protect the uncomprehending children within the state from the sterilizing and mutilating pharmaceutical and surgical ministrations of medical personnel whose inflictions upon such children are offered in the name of treating gender dysphoria. That is, these technicians exploit and perpetuate rather than correct the child's transient, though profound, confusion about his or her sexed identity. Well, the ACLU brought suit to have this Tennessee statute declared unconstitutional, and the Biden administration intervened in the case to argue the statute to be a violation of the 14th Amendment's Equal Protection Clause, thus the inclusion of the United States in the caption before the Supreme Court. I will suggest that the dispute in the Scurmetti case, amply understood, raises questions as to whether there is a human nature, whether male and female are objective conditions of identity that state law may recognize, and whether the state may protect vulnerable children within its borders from the medical assaults upon them in furtherance of a denial of a given human nature. In sum, properly under consideration in the case is whether states may refuse the novel proposal that a child is a blank construct for coached self-definition and medical adventurism, and further, whether states through legislation may refuse the consequences to law and society that would obtain if such a radical departure from human integrity and community precept were made normative. So the Tennessee statute under challenge here accomplishes far more than prohibiting child abuse by medical professionals. The statute serves to instantiate and thus reiterate and hold steady the law's proper and vital recognition of sexed human nature. Tennessee's argument offered in its defense that states have a long-standing authority to regulate the practice of medicine is, at best, a companion to, not an adequate replacement of, the far more encompassing point as to the anthropological and legal disruption implicated in transgender theory and its policy proposals. Now, to be sure, the data points about medical harm to children are important to register and are indeed bases for state regulatory action. but they manifestly fail to capture the heart of the matter, which is metaphysical rather than merely hormonal, and thus implicates human society as such. But recall my lament that our late modern decline has our policy resolving determinations considered and explained publicly in exclusively empirical ways, even while the man on the street may know or suspect or hope that these are but proxy arguments or stand-ins for the far more consequential reality of male and female as radical aspects of human meaning, civilization, and indeed cosmological order. Consider, for instance, that once male or female embodiment no longer legally anchors human identity, the venerable practices and policies dependent on the identity profundity of male and female bodies only survives as fugitives or in a tentative position of contingent government permission, ever vulnerable to in fact erasure that is already accomplished in principle. So, for instance, draining legal meaning from body in its natural functions correspondingly drains legal weight from the body concepts of motherhood, fatherhood, kinship, ancestry, from family itself. And it's here that we can pause to observe the immaculate logic that's in play when courts which adopt gender ideology as their guiding precept likewise act to remove custodial authority from parents who refuse to participate in the social or medical transing of their children. In an early case of this sort, an Ohio judge ruled to remove custody from the mother and father of a trans-identifying teenage girl because they would not honor the daughter's right to change sexual identities via cross-sex hormone infusions. Well, of course, if a child's given sexed embodiment has no legal valence or meaning, then neither can have legal valence and meaning the offices and sex categories of mother and father. In such case, what remains in the world would appear to be isolated, relationless individuals on the one hand, and the state on the other. Another notorious example of this sort was present in a case in Canada in which the judge ruled against the father of a trans-identifying daughter, ordering him not to address his daughter by her given female name, nor use female pronouns when speaking about her. The judge himself in his ruling wrote of the daughter as the father's son. When the father violated that order, the judge imprisoned him. Recently, the U.S. Supreme Court declined to review a case out of Indiana involving parents who had the custody of their son removed because of their refusal to refer to him with a female name and female pronouns. The trial court further forbade the mother and father to speak to their son about their convictions on matters of sexuality and gender identity. An Indiana Court of Appeals affirmed that order. And legal standards in certain U.S. states continue to make parents' custody dependent on their cooperation with the transing of their children. Again, you see, if our sexed bodies are legally meaningless, then the family itself is vulnerable to erasure. The state can meddle in or do away with it with impunity and do so without violating any natural reality. For there is, of course, no such thing as natural or authoritative meaning in our bodies on the trans or the genderists' telling of things. So back to the Skermeti case and the contested Tennessee law. Now, I've belabored the point on the legal anthropological perils implicated in the trans machine because all those considerations were absent from the arguments before the Supreme Court in the Skermeti appeal. And this is, of course, due in part to the moral, anthropological, and, of course, theological vacancy in constitutional analysis that has become essentially mandatory in recent decades due to the court's constitutional jurisprudence. Therefore, Tennessee simply proceeded in terms of the approved immanentistic categories that comprise contemporary legal standards. It wishes to win, after all. That is, Tennessee, in defending its authority to enact its contested statute, argued that the Supreme Court has long conceded that states may regulate treatments involving medical and scientific uncertainty. So the Tennessee Solicitor General argued before the justices that this was a context of just such medical debate involving unsettled health questions, an evolving medical issue, which invites an exercise of weighing the benefits versus the risks of certain treatments, which is a task properly left to the Tennessee legislature rather than to the courts. Now, notably, this is an argument that is in keeping with the logic of transgenderism itself. As a result, even if the Supreme Court upholds the Tennessee statute on these terms, the gender identity thesis is not only unscathed, but arguably strengthened for having emerged from this conflict unimpeached. If the Tennessee statute is vindicated exclusively in terms of the legal propriety of state regulation of pharmaceutical prescriptions when their empirically measured harms and benefits remain legitimately contested, this is a win for the trans program, especially if the court, in its ruling, tiptoes around, carefully ensuring its use of language and analysis honors the conceptual demands of gender ideology. On that point, I'll mention that in the Schermetti oral argument at the court, there was an unprecedented and I would say momentous event in the proceedings when the ACLU attorney Chase Strangio, who is a woman who declares herself a man and through hormone infusions has grown facial hair, was invited to the lectern to argue by Chief Justice John Roberts, saying to her, "Mr. Strangio." This marks the first time on the record at the High Court that a Chief Justice has succumbed to addressing a female attorney as a male. Now, the Chief at least had the excuse that the unvarying convention of the Chief Justice when calling non-government attorneys to the lectern is by saying Mr. or Ms. plus last name. And if he had not said Mr., but instead Ms., it would have sparked an international news event that would have made his life miserable for quite some time. On the other hand, Justice Barrett had no such pressure upon her, yet she determined during questioning gratuitously to call counsel Mr. Strangio. Also, several justices during questioning adopted into their discourse the insensate, though gender ideology mandated neologism, sex assigned at birth, as if the word sex alone is inadequate. Instead, sex is understood and thus spoken of as a punctuated moment in time that disappears after birth, evidently, leaving us, if we are to speak of it, to be able to do so only by looking back to that brief moment long ago when it was assigned. There were other examples of this sort of thing during the proceedings in which most everyone in the discussion at the court, in more or less explicit ways, spoke as genderists speak, or avoided speaking in a way that would noticeably collide with the genderists' language dictates. And this is the tiptoeing that I mentioned, and why I suggested that even if Tennessee wins this case, as I expect it will, the ACLU may also have its win, though on a more profound and radical level than that victory of the state of Tennessee. Now, I've spoken with students in one of my courses about the deposition testimony given by the notorious child transing doctor, Joanna Olson Kennedy, from Children's Hospital, Los Angeles. She, testifying in that deposition as an alleged expert witness enlisted for the subject case, leaned into this word inversion for all it's worth. Though she has referred hundreds of young girls for double mastectomies, in her testimony, she explained, no, that's not in fact true. For as she explained under oath, first of all, she referred these patients for male chest reconstruction, not double mastectomies. For her referrals were all for young men or those on the transmasculine spectrum. They're not girls, she insists repeatedly, defying the questioning attorney who speaks of her pediatric patients as girls. And for this reason, I suggest that Olson Kennedy's testimony is not as a medical expert or scientist, but as a fanatic. And she exemplifies how discourse proceeds with these activists by an assiduous insistence on using a defiant inversion of vocabulary, not just as a means to whitewash their conduct, but to deprive the community of the very words needed to indict them for what they do. One of the young girls victimized by Dr. Olson Kennedy is Clementine Breen. The day after the Supreme Court heard oral arguments in the Skermeti case in December, Clementine's lawyers filed suit on her behalf in California Superior Court against Olson Kennedy and the Children's Hospital Los Angeles, among others. The lawsuit contains a horrifying narrative, though it merely details one instance of what is, in fact, the workaday operation of the life-ruining trans machine. As her lawsuit alleges, Clementine is a female who suffered from a complex, multifaceted array of mental health symptoms as a child and adolescent. She suffered prolonged sexual abuse around the ages of 6 and 7. She suffered trauma from a volatile and difficult home environment. Her family also has a lengthy history of mental health issues. Yet her school counselor told her she was transgender, and having been saddled with that designation, Clementine went to meet with Dr. Olson Kennedy at the Children's Hospital. At that first visit, after mere minutes and performing no mental health assessment, Olson Kennedy diagnosed Clementine with gender dysphoria and recommended surgical implantation of puberty blockers, to which Clementine submitted. She was 12 years old. Olson Kennedy put her on cross-sex hormones at age 13. Also at 13, Olson Kennedy referred Clementine for a double mastectomy, a surgery that Clementine then had at 14. Years later, Clementine has emerged from her identity confusion, but now must live with a profoundly altered body that is beyond repair. Her case is like that of countless other children who have been waylaid and victimized in this way. A pox on this belligerence. And God's blessing on Tennessee and all the other states, Idaho included, that have banished this criminality from its midst. I'll now turn to speak more generally about the indispensable role of the law holding in place the vital aspects of community order. In that regard, I offer the following. The goal of the freedom-prizing community cannot properly be to achieve a legal order that is indifferent to truth, in which a plenitude of personal self-defining options is available for citizens' private pursuit. That sort of aseptically procedural endpoint is neither ultimately attainable nor worthy. The world is meaningful. It is God's world, and justice requires conformity to truth as he has given it, just as freedom does, if it is to be freedom. Of course, in our late modern decline, the truth of anything non-empirical, like the common good, has become an inscrutable suggestion to many among us, unless understood to mean something like the aggregate condition of stimulated and satiated individuals. Or perhaps the common good is to refer to the omnipresent state procedural system that enables and facilitates all of our acts of self-identification. But either of these makes incoherent the idea of community with its necessary common points of reference to knit us together amid our natural diversities. Jim Kalb once wrote, "It is hard to make sense of a call for particular public loyalties in a country that is increasingly understood less as a concrete community united by history and culture than an abstract legal order devoted to security, choice, tolerance, and physical well-being, with no connection to any particular cultural or religious tradition and no loyalty to any history other than the history of a governing regime that abolishes all other social loyalties." End quote. When humanity is deemed a cluster of indeterminate, unspecified, interchangeable vectors of wish, the legal political condition, by definition, cannot countenance the constraint or authority or even existence of a shared or common good of truth. As such, the liberal state professes responsibility merely to manage the preference pursuits of individual actors. Government-determined limits on those pursuits will be ultimately arbitrary rather than in deference to an anterior truth of being, as, recall, there is no such thing on this account. Statecraft in such a model can only be totalitarian in principle, if not always or not yet in clear enactment. As social harmony has no rational and natural path to tread, group cohesion is achieved either through inexplicable coincidence or the imposition of necessarily arbitrary force to add a kind of form to our otherwise shapeless mass. What kind of force? On its account, it wouldn't matter. As Robert Spemann observed, it is impossible to do violence to a human nature that is not ordered to anything. So don't miss the dynamic in play here. Free choice for the individual that is liberated from objective and visible truths is, in the same way, free choice for the state, released from restraints on its whim and grasp. When the state, in the name of liberty, eliminates meaning and telos from human personhood, it likewise removes from itself an orienting and restraining counsel. Robert Nisbet has argued at some length that totalitarianism becomes possible and follows on from the renouncing and dissolving of real relations and associations and their authority. He writes that the political enslavement of man required the emancipation of man from all authorities and memberships that serve in one degree or another to insulate the individual from external political power. The later 20th century judicial condemnation of, and otherwise the regulatory dropping of historic legal regulations of profanity, blasphemy, indecency, pornography, sexual deviance, and the likes of these, were not accomplishments of limit upon state power. They are and have been the statism-enabling elimination of the community's authority to sustain in truth its common life together, free of the chaos from affronts to its vital sensibilities and from the corrupting of the persons, defining precepts, and the organic and non-state institutions that compose it. Judge Bork once suggested that G.K. Chesterton might have been addressing this very controversy when he wrote, "What is the good of telling a community it has every liberty except the liberty to make laws? The liberty to make laws is what constitutes a free people." End quote. The long-running judicial project of de-Christianizing the U.S. legal political order has been facilitated by a great extent by forbidding communities to protect and sustain themselves by and through continuance of their centuries-enduring practice and prerogative to maintain common law standards that preserve decorum and order, within which social harmony and its multi-institutional and associational community life itself is sustained. As our courts have invented new individualistic rights to pollute and coarsen the discourse, imaginations, conduct, and visual landscape of the polity, this has not facilitated freedom. Instead, it has eliminated the conditions for its realization by undermining the means to retain a moral ecology and a conceptual climate necessary to the survival and health of free associations and institutions. The late legal philosopher Joseph Raz has observed, for instance, that, I quote him, "Monogamy cannot be practiced by an individual. It requires a culture which recognizes it and which supports it through the public's attitude and through its formal institutions. To deny the community its law, the law needed to preserve the integrity of its defining associations and institutions, and to hold at bay the sources of threat to them, is the conceptual equivalent of proposing a country without borders or an army. It will be overrun." And so it has. So now moving towards some encouragement and a conclusion. The socially remedial work against the trans insurrection includes necessarily the employ of law. Just as law's perversion has been a chief mechanism of the trans imposition. And on that front, it is with quite some gratitude and relief that I mention President Trump's several executive orders denouncing gender ideology and banishing its promotion and policy enactments from all federal programs, operations, and federally funded entities to the extent of legal availability. And this with the Attorney General's office and other agents of enforcement enlisted to scour the federal government and pursue the vindication of this turnabout. These executive orders serve to flip a decade of federal administrative policy that promoted trans ideology and policy as a priority to be visited upon every aspect of U.S. influence and administration, both domestic and foreign. That is now over. The president's first day executive order states that the policy of the United States is that male and female are not changeable and are grounded in fundamental and incontrovertible reality, reciting also that the erasure of sex in language and in policy has a corrosive impact not just on women, but on the validity of the entire American system. Another of his orders speaks of the trans medical mutilation of children, using that phrasing, as a stain on our nation's history. 2 days ago, and in another executive order, the president declared the policy of the United States to be vigorously enforced through Title IX, forbids the invasion into women's sports of males. That U.S. policy, he explains in terms not just of safety and fairness, but of truth. And attending all of these clarifying descriptions is a host of policy change orders, removing from the massive federal government apparatus the countless instantiations of sex-defiant policies. Now, while these orders are going to be challenged in court, and of course they are not sufficient in themselves to fully address the larger trans affliction, the executive orders are nonetheless astonishing in their suddenness, in their plain-spoken truthfulness, and in accomplishing a complete reversal of the federal government's policy direction, both in word and in deed. Also, we should gratefully observe the legislation enacted in close to half of the states that pushes back on various aspects of the trans program, from protecting sex-specified restrooms and locker rooms, to women's sports, to restrictions on medical professionals transing minors. And public interest litigation that presses the rights of institutions and parents and individuals as against the demands of the trans program also is in full swing, with successes being attained. All to say, we are now in a time long overdue of vigorous and visible public denunciation and prohibition of the trans program. We just might be coming to see that an incoherent anti-human ideology that strains everyone's credulity and ruins everything it touches is not a sustainable foundation for community life or the law that governs it. I pray that the recent enactments and the remedial discourse and conduct it empowers and furthers represents a real turning point toward a thoroughgoing legal cultural refusal of this ideology. And that it also will lead in time to a reconsidering of the sexual revolution more broadly, which has brought such disintegrating ruin upon us. In your mercy, Lord, we implore, may it be. Thank you.